So good morning, ladies and gentlemen, dear colleagues. It's a true pleasure to welcome you all and welcome you to this conference on the influence of the ICJ and PCIJ judgments on international investment arbitration. This one-day forum is organized by the World Arbitration Update and is being hosted here in The Hague by the Grotius Center for International Legal Studies of Leiden University, which is the International Law Department. This is one of our buildings in The Hague campus. We have several of these. This is one of our nicest buildings, so it's a true pleasure to welcome you all here. I'm going to be very brief because the introduction to the forum will be done by Mr. José Antonio Rivas, who is one of the organizers, and I want to thank him for having asked us to host this wonderful event, and to all of you for having accepted to speak here today or to participate as part of the audience. So welcome. And I wish you a very fruitful day. Jose, the floor is yours.
Thank you, Eric, Professor Mary, and as indicated, and my name is José Antonio Rivas. Just as a matter of introduction, I've been in Washington, D.C. for most of my professional career, and I teach at Georgetown Law, and I practice investment arbitration. This is a project that really started many years ago, together with co-founder of World Arbitration, Attila and Laird, and we have been working with a very persistent group of doctors and legal professionals on putting this day for, I would say, more than 2 years, especially with Reza, who is here present, also with Eric, and also with Professor Hadi, who have been, to be frank, obsessive in trying to have a session that meets two communities. One community of public international law and experts on ICJ, PCIJ judgments on the one hand, and the community of individuals who have practiced investor-state arbitration. This under the strong rational belief that to understand and to really be comprehensive in investment arbitration, either as counsel, arbitrator, or even academic, you need a strong foundation in public international law, and a strong foundation and understanding of ICJ judgments, PCIJ judgments, which are not passé. And I would like to emphasize that. Yes, we have decisions that are perhaps of last century, but today, in the latest days, we still, and thank God, we see ICJ judgments which are influencing, hopefully, investor-state arbitration. With that, I would like also to say that nous tenons aussi tout particulièrement à remercier le professeur Jean-Marc Touvenin pour sa présence. Et vraiment, c'est un honneur pour nous de vous accueillir. Ce projet, comme je le disais en anglais, une journée consacrée à l'influence des arrêts de la Cour internationale de justice dans l'arbitrage en matière d'investissement, s'inscrit dans le cadre du Washington Arbitration Update, qui a pour objectif, d'informer notre audience des évolutions récentes en droit international public, et ce, dans une logique de décentralisation de l'arbitrage international, pour avoir des conversations non seulement à New York ou à Paris ou même à Londres, mais partout le monde. Et cette journée repose sur l'idée selon laquelle le droit international public est au cœur de l'arbitrage international en matière d'investissement. alors vraiment, c'est un honneur de vous avoir. And especially because we know that the world is busy and there are meetings with Curatorium, perhaps even tomorrow. So we really appreciate having you here. And so with that, the floor is yours.
Thank you very much, and the honor is mine, to be absolutely clear. I just want to make also clear that I'm not here because I lost yesterday or won yesterday a case before the ICJ. I was not involved, so it's not my fault. Yeah, it's an honor to be here. Leiden University, no doubt one of the star universities, particularly when it comes to international law, both private and public. So I'm very much, yes, honored to be here and to have been requested to provide a keynote speech. I must disclose 2 points. Yes, I practiced before the ICJ. I'm also on the list of exceed arbitrators now, nominated by Senegal, which is funny, but it's the thing, and I'm very proud of that. And I've been involved in certain cases I will talk about, but not much, but in particular, certain Iranian assets. So this being said, today's forum is devoted to the topic of the influence of PCIJ, ICJ judgment on investment arbitration. And this is, of course, a very topical issue, and there is much to say and much will be said today. But the title, as it is worded, raises to me a question of whether there is any influence to be examined with respect not only to judgment, but also to advisory opinions. And advisory opinions of the ICJ are very popular nowadays, and also advisory opinions of ICLO. So perhaps one reason for not including advisory opinions in the discussion might be that they are not binding. And if they are not binding, perhaps someone suppose that they cannot generate a jurisprudence. But this would be a misunderstanding, I would say. 2 years ago, the Institut de Droit International adopted a resolution aimed at formulating guidelines for the identification of an invocation of precedents in permanent international courts and tribunals. And its title is Precedents and Case Law in Interstate Litigation and Advisory Proceedings. This title was specifically coined to include advisory opinion because all institute members were convinced that advisory opinions participate to the case law. And indeed, they have authority and cannot be ignored simply because they are not formalistically binding. The special chamber of the ICLOs in Mauritius versus the Maldives confirmed that, and I quote, judicial determinations made in advisory opinions carry no less weight and authority than those in judgments because they are made with the same rigor and scrutiny by the principal judicial organ of the United Nations with competence in matters of international law, end quote. Now, it is true if you look closely that the Institut de Droit International in its resolution did not touch upon what goes on in ISDS, since it focused its resolution on interstate courts and tribunals. However, the 7th guideline of its resolution provides that the principles set out in these guidelines could be applied by analogy in non-interstate proceedings. So as a first remark, I should say that the advisory opinion should perhaps not be disqualified from the reflection. And indeed, advisory opinion had an influence on exceed arbitration. The doctrine of res judicata, applied as a general principle of law in Apotex versus United States of America, is directly rooted in an ICJ advisory opinion of 1954. I note in passing that in Apotex versus United States of America, the PCIJ and ICJ are abundantly cited regarding how to assess the res judicata effect of the prior awards. So it's very instructive. Another example of an ICJ's advisory opinion influence can be found in the now jurisprudence constante of the ad hoc committees regarding the obligation to state reasons. In AMCO Asia versus Indonesia, the ad hoc committee specifically referred to the ICJ's advisory opinion in FASLA case of 1973 as fixing the position that tribunals do not have to enter meticulously into every claim and contention by each side in their statement of reasons. So the FASLA advisory opinion, which of course authorizes or recognizes that judges do not have to explain everything which is behind the reasoning, has clearly inspired ICJ arbitration. Recently, it was stated in Soufraki versus United Arab Emirates that reasons set out in an ICJ arbitral award do not become insufficient or inadequate simply because such reasons are not documented by citations to the relevant case law or literature. So, but based on this position, even if the ICJ, PCIJ case law is or could be a source of inspiration for a given investor-state case, arbitrators are not necessarily required to explicitly refer to it. Therefore, it's possible that arbitrators sometimes rely on this case law without explicitly stating so. They might, for example, prefer to refer to the work of the ILC without quoting the case law that the ILC codifies. It's its job. Alternatively, they may refer to prior investor-state awards rather than the case law that inspired them in the first place. And of course, there is nothing to complain about here, since there is no stare decisis in international arbitration and more generally in international law. And one of the reasons for the absence of stare decisis in international law is, in my view, that it would be contrary to the principle that put apart customary international law, and there is debate on that, a state cannot be submitted to any obligation without its consent. It follows from this principle that if a state has not consented to be submitted to the authority of a prior decision rendered between different parties, then this prior decision cannot be opposed to it. Yet, it might be relevant for arbitrators to treat PCIJ and ICJ decisions as precedents. And regarding the notion of precedents, the first resolution of the Institut de droit international I've just mentioned is worth quoting, in that it defines what is a precedent or what is case law. I quote, "A precedent or case law may be used in support of a judicial pronouncement if they concern legal issues comparable to the case at hand and if the reasoning behind them remains relevant at the time of the pronouncement. Established case law, meaning a body of concurring decisions, may be set aside for a legal reason duly stated, notably in light of the evolution of international law." End quote. And of course, the second quote is quite controversial. So referring to precedents in investor-state arbitration is generally favored. And here let me refer again to the Institut de droit international, but this time in its Tokyo resolution titled especially legal aspects of recourse to arbitration by an investor against the authorities of the host state under interstate treaties. And its preamble advocates for, I quote, the desirability of creating consistent jurisprudence that would promote reasonable predictability and the confirmation and consolidation of the rights and obligations of both foreign investors and host states. So there is this idea that the consistent jurisprudence should be favored in order to promote a reasonable predictability and consolidation of rights and obligation of all concerned. So I believe that this approach reflects a position largely agreed upon, and which of course is reflected in the current reflection on the reform of the ISDS. This position is, as you know, that although each ISDS case is unique and governed by a specific BIT, the law applicable between subjects of international should be reasonably predictable. Thus, if the very same principles or rules are at stake in two or more comparable cases, they should generally be interpreted in the same manner and generate the same outcome. At the same time, and this is the other side of the coin, international is surely not made of frozen principles and rules. Evolution of international law is a reality, and this should not be precluded by outdated principles and rules. Referring to past decisions is therefore certainly useful for the sake of consistency, which triggers somehow legitimacy. True that it has been opposed to this idea that there is no good reason for allowing the first tribunal in time to resolve issues for all later tribunals. This is quite a strong statement saying, well, why would we respect what has been said before? We are as legitimate, we arbitrators, to decide what the law says. I agree with this statement, to be frank. I know that my friend Alain Pellet has been shocked, I'm not. Precedent, I must precise, is not any prior decision dealing with a comparable legal or factual question. It is a decision rendered by an international court or tribunal, which may, doesn't mean that it must, it may serve as a reference in a case other than the one in which it was rendered. And for a decision to be capable of serving as a reference, it must be seen as a precedent. That is, it must have or been recognized a certain authority. And such authority can derive from the quality or persuasiveness of the reasoning. It can also derive from the statute of the institution that rendered the decision. So there are many, or some different features that will qualify as authoritative a decision. But the most important one is the quality of the reasoning and the topicality of the solution rendered. A decision can also appear as not very authoritative and then will not be seen as being capable of serving to resolve future issues. It will be the case in particular when the reasoning is not so much detailed. The selection of what decision should serve as useful precedent is therefore important. The good selection triggers the good application of the law. Indeed, as been said, an emergent jurisprudence constant based on a defect in legal reasoning is not something desirable. And here, the inherent authority of the PCIJ and ICJ, let's say the World Court, even if at the time of the PCIJ, I'm not sure it was really a World Court, and not to speak about other periods of time. So the inherent authority of the PCIJ and ICJ, the World Court, might explain why arbitral awards referring to PCIJ, ICJ decisions have not been rare in the past practice. This has been already widely explained in different writings. I spoke about Alain Pellet, and of course everybody knows his Lalive lecture of 2013, but there are many others that are also PhD theses. So the conclusion arrived at by numerous observers is that one, references to World Court decisions are common ground in ISDS proceedings, and two, some judgments are particularly popular in ISDS practice, and this is what will be developed today, I guess. And I should say that this popularity of certain judgments is not necessarily because parties themselves refer to these judgments. Of course, it is expected from learned practitioners to provide all authorities that support the thesis of their clients. If it was not the case, counsel would not be so well paid. And if there is something in the World Court's case law that to this effect, they should provide it to the file and exploit it in their argumentation. Perhaps even call for experts to explain what the case law says. But if the parties do not use this opportunity, it doesn't preclude the arbitral tribunal to refer to this case law in its award. Indeed, even if there is a debate about the limits of what the jura novit curia doctrine permits, and on this point, I would call you to read carefully the excellent course given by our friend Attila Tanzi at the Hague Academy on jura novit curia. It is the Bible. Even if there is a debate, it is generally admitted within the ICSID system that decisions not cited by the parties can be referred to by arbitrators. For example, in RSM Production versus Granada, the ad hoc committee signed of an application to reopen the case. It was a bizarre case on the basis of allegations of corruption. Noticed that, and I quote, although not cited by the applicant or the respondent, there are there are a number of other arbitral decisions which deal with the power of international courts and tribunals to reopen a case for newly discovered evidence. On the basis of the principle of jura novit curia, the committee is able to consider the relevance of those decisions, and the committee referred there to the fisheries jurisdiction case and the Nicaragua versus United States case. There are other decisions in the same vein. So, of course, the fact that the ICJ is the principal judicial organ of the UN, World Court, is not a sufficient reason for arbitrators in ISDS to refer to its decisions. In addition, the questions addressed should correspond to those that are relevant for ISDS. It can be so when it comes, and we all know that, when it comes to issues like inherent power of the tribunal or court, admissibility of counterclaims, binding effect of provisional measures, binding or not binding effects of provisional measures, interpretation of treaties, in particular certain standard provisions, and we know that standard provisions are subject to a lot of debate, burden of proof, notion of dispute, etc. So yes, it makes sense that reference to PCIJ ICJ case law is not rare in ISDS, but it is also sometimes only to explain why it is irrelevant in casu, and that's a very smart way of putting aside what is supposed to be the statement of what international is, to say that, well, the situation is different, the case is peculiar. And sometimes it is done with much more creativity and audacity, perhaps, than what you might expect from, for example, the ICJ. A good example is given, in my view, in Casinos Austria versus Argentina. In its award on jurisdiction, the majority considered, apropos a compromissory clause in the relevant BIT, that, and I quote, unlike in interstate dispute settlement, where the ICJ has insisted, in certain cases, on the strict compliance with conditions of seizin under compromissory clauses, the tribunal considers that unless pre-arbitration requirements are formulated clearly and unmistakably as strict conditions to the validity of the seizin, in investment treaty arbitration, a more flexible and less formalistic approach is warranted. An investment treaty tribunal should accord greater flexibility to the disputing parties than the ICJ accords to conditions of seizin under compromissory clauses. The tribunal had, or the majority held further than that, I quote, the pre-arbitral requirements in Article 8 of the BIT, which is the compromissory clause, concern the validity of claimant seizin and do not go as condition precedent to respondent's consent to the question of jurisdiction. So the dissenting arbitrator, himself a former registrar of the ICJ, so he knows very well the practice of the ICJ, I must say, he has been judge ad hoc also in certain cases, strongly criticized this position, stating that it is untenable in the face of the established jurisprudence constante of the ICJ. And I must admit that when it comes to assessing the existence of the consent of the state to be submitted to anything else than himself, I suppose that flexibility and not formalistic approach is not the most appropriate approach in the eyes of the respondent states. At this point, and I'm close to the end, it is fair to say that the ICJ, in return, perhaps, is now referring to investor state awards, sometimes to reject their relevance, but with good reasons, sometimes to take them as precedents. So in certain Iranian assets, the ICJ had to decide whether the Central Bank of Iran, Bank Markazi, did perform commercial activities in the US when it was subject to the treatment, the US treatment complained of by Iran. And that was the very question that this case was putting, because if Bank Markazi was performing commercial activity at the time, it was a company under the treaty and would have benefited from the protection of the treaty that Iran was putting forward. The USA, in response to the arguments of Iran, always focused on the idea that what counts to determine if there was commercial activities at stake was the function performed by the central bank and not its activities as such. And there was a debate on that. On the basis of the judgment on premier objections, it was fair to consider that the court had decided to give priority to the practice itself, not to the function. But it was not clear. On the basis of the assumption that it was commercial activities as such that were to be looked at, Iran invoked the CSOB versus the Slovak Republic award to demonstrate that even when a bank is performing governmental functions, acting to promote the governmental policies, its activities can be commercial in nature. This is what is said in CSOB. And so this is why Iran was relying on that. But the court set aside this award as of little relevance because it changed the path. And it considered that what matters to determine whether Banque Markazi is a company under the treaty that was a state was not really the nature of the activities, it's rather the functions that were carried out by this bank. And of course, it was governmental functions. It is a central bank, and the central bank is promoting the policies of the state. So the court rejected this case. It also rejected the relevance of a case put forward by the United States of America, Sergei Poshov versus Mongolia, for other reasons. But what is interesting here is that this treatment suggests that if the case law, if these decisions had been relevant, then the court would have taken them into account. And this is exactly what the court did in referring to two cases, Setko versus Iran and Saluka versus Czech Republic, as part of a jurisprudence constante confirming the relevance in Customer International of the police powers doctrine, according to which the bona fide non-discriminatory exercise of certain regulatory powers by a government aimed at the protection of legitimate public welfare is not deemed expropriatory or compensable. So the court did take account of these awards as establishing or confirming a jurisprudence constante. And as you know, it's the second time the ICJ, as far as I know, it's the second time the ICJ makes explicit reference to investor state awards, the first being in Diallo, referring, but I think vaguely to Burling versus Ghana. So to conclude, there is a sort of dialogue between the World Court and Investor State Tribunal. In a certain manner, the fact that the ICJ nowadays takes investor state awards, I would say seriously, appears as a kind of a tribute paid to investor state arbitration at a moment when it is under huge critics. At the same time, one can wonder whether more reference by arbitrators to ICJ decisions could improve the legitimacy of ISDS by fostering coherence, transparency, and alignment with international norms, therefore addressing the criticism of inconsistency and bias. So this is up to the discussion. Thank you for your patience, and I wish you an excellent forum, one-day forum on this very interesting topic. Thank you very much.
And just informally sharing with you you all have the program. You have all received it, and for just also as a matter of information for everyone, something that I did not say at the beginning of the introduction. in addition to the two objectives that I stated, one of updating the international community in international arbitration and public international law, as well as through decentralizing international arbitration. The World Arbitration Update is a form that happened in many continents the same week. So while we are here, this is the first day in Europe, and then tomorrow we'll have Singapore, and then we'll have Washington and Mexico, ending in South America. All this is shared with the various places through the internet. This is one of the good elements that left COVID, which left us interconnected. So in a very sort of public law and societal effort, attendance to WOW, that's how we call it, is free of charge, and it's normally recorded so that people are able to go back to the lectures, to the panels, and learn from them. So while we're being about 25, 30 people in the room, you are being observed and watched throughout, or will be. So, and with that, the floor is yours, and thank you for having me here.
Thank you very much, Jose. A quick thank you to WOW and Leiden University for putting together this wonderful event and inviting me to moderate this particular introductory seminar where we get to talk about what happens on both sides of the Peace Palace here in The Hague. And our job for this first 30 minutes is to introduce a few of the topics and whet your appetite for the more in-depth panel discussions that will follow later today. And to do that, I'm accompanied by two distinguished guests who are very well versed not only in investment arbitration, but also in the world of the International Court of Justice, and indeed in other international courts and tribunals, both here in The Hague and beyond. Starting with Professor Attila Tanzi. He is Chair of International Law at the University of Bologna, President of the Italian branch of the International Law Association, and Associate Member of 3 Verulam Buildings, 3VB Chambers in London, a seasoned counsel, arbitrator, and scholar in both interstate and investor state matters. He brings a lot of experience in all of these various areas. And we also have with us today Paris Aboro, who is International Dispute Special Counsel at Covington and Burling in New York, until recently now in London, there with experience in investor state and commercial arbitration, as well as the representation of sovereigns in many of these international courts and tribunals. She's previously served as legal advisor of the Iran-US Claims Tribunal here in The Hague, and lectures also at Columbia Law School in New York. Now, both have far more accolades and deserve a longer introduction than that, but in view of the limited time, let's launch right in, starting with you, Paris. I'd just like to ask you a little bit about where and how investment treaty jurisprudence has actually featured and been treated by the International Court of Justice, and vice versa. How has the jurisprudence of the ICJ been treated in investment arbitration as well?
Thank you, Martin, and thank you to the organizers of WOW and to Leiden University for having me today. Well, I think Jean-Marc gave an excellent preview of how the court has approached investment treaty jurisprudence and vice versa. And as Jean-Marc noted, the court has really relatively infrequently been called upon to consider or apply international investment law and cases. And where it has done so, generally speaking, it has distinguished those cases for better or worse and for good reason and otherwise. In addition to some of the examples you heard from Jean-Marc, just to give a few more concrete examples, we have the reference in the 2018 judgment, obligations to negotiate access to the Pacific Ocean, Bolivia versus Chile. in which Bolivia had sought to rely on ISDS case law related to legitimate expectations to argue that it had an expectation that Chile would restore Bolivia's sovereign access to the sea. And the court noted the ISDS case law cited in that case, it was Gold Reserve versus Venezuela, but did not find any support for legitimate expectations in general international law. Similarly, the court distinguished case law in Diallo related to the standing of Guinea to bring claims concerning actions against companies as distinct from the shareholders. And certain Iranian assets that Jean-Marc referred to is an interesting and notable departure from this practice of the court referring to and distinguishing cases, because it did reference with authority the decision in Saluka, as Jean-Marc mentioned. So on the other hand, if we look at the way that ISDS tribunals have tended to approach PCIJ, ICJ case law, they've approached it with varying degrees of deference. The main reason for reference to such case law is, of course, the authority of the court on general principles of international law, such as treaty interpretation, state responsibility, as well as more substantive issues of customary international law. And in this context, ISDS tribunals have noted the authority of the ICJ. Over the course of today, you will have an overview of all different aspects of ISDS practice and the way that ICJ jurisprudence has touched upon those different aspects, be it from jurisdiction, merits, and quantum. So just to provide some introduction to what will come, the most frequently cited cases in ISDS practice are in reverse order, I suppose, of the issues. So beginning with damages, of course, the Chorzów factory case, in which the court articulated the standard of full reparation for injury caused by an internationally wrongful act. You also have repeated reference in ISDS case law to the LC decision by the court, which is most frequently cited for its discussion of the standard of arbitrariness, recognized as an element of fair and equitable treatment and relevant also to other substantive standards. And then you have additionally frequent reference to the case of Barcelona traction, the logical follow through of which was Diallo, in which the court held that Belgium lacked standing to bring a claim on behalf of Belgian shareholders who indirectly owned the allegedly damaged investments. The interesting thing about the reference to Barcelona traction is, unlike Chorzów factory, Barcelona traction is more often than not distinguished by ISDS tribunals. So as Jean-Marc noted, we have this dialogue between the two different sides of the peace palace, which has really contributed to both practices.
Thanks, Barris. I think now we have the leaderboard, and in fact, the ICJ's penchant for distinguishing investment treaty jurisprudence, and indeed in distinguishing itself in Barcelona traction and Diallo there. Turning to Attila, however, what exactly is the legal basis on which the ICJ is engaging with investment treaty jurisprudence? And how should or does the ICJ actually have an impact then on investment treaty arbitration thereafter?
Well, thank you, Martin, and thank you to the organizers for having invited me to listen more than to speak. I will be listening more than I will be speaking, and therefore benefiting a lot. Thank you, and thank you, Martin, for moderating. I mean, this is a key question which has been largely addressed by implication by Jean-Marc. I think it is, self-evident, but often overlooked, that investment arbitration tribunals find themselves to have to go to look for interpreting, apply the law which goes beyond the four corners of the body of investment law. For many years, scholars, commentators have focused on treaty law for purpose of interpreting and applying the bilateral or multilateral investment treaty to the body of the law state responsibility for purposes of attributing responsibility and the consequences thereof. And the rest will solve lots of fundamental public international law issues, such as statehood, state secession, or deference to be paid to domestic judgments, or even ongoing proceedings that fall well beyond the body of international law, where par excellence, the statement of the International Court of Justice set important relevant standards that would be strange for investment tribunals not to rely upon. Now, as the legal basis, I see very much a twofold approach. The first leg is to be found in the same foundation for which an investment arbitration tribunal finds itself entitled to, or even obliged to have to apply public international law. To start from the actually applicable law clause in the applicable treaty, you look at Article 42 of the ICJ Convention, where we are not under the chapeau in The Hague or in Vienna or somewhere else in the world. Of course, Article 31(3)(c) is indeed a channel for you to have as an arbitrator to look at the statements of the court. And the second leg, perhaps it's overarching, is the application to investment tribunals of Article 38(1)(d). This was a point that was strongly and simply restated by the AWG versus Argentina tribunal, but I think this is a general assumption that is being elaborated worldwide. One last remark about how, I mean, computational analysts may not be very happy about the fact that the impact of world courts judgments are not to be taken into consideration only when the given award or decision in question explicitly refers to, and this is a point that Jean-Marc made, to a given statement. So you can number all the and spot which statement has been having an impact. But from experience, what I find very relevant and extremely determinant for purposes of what is going the award to be like based on what the court said, is that when you meet sometimes in the margins of, at the end of hearings, and you start discussing amongst the arbitrators about the directions to take, and you start looking at the way the reasoning is going to, when you test the water and you want to make an argument, you very much tend to rely on authoritative ICJ statements. And then I suppose that in due course we'll get into, as Jean-Marc already alluded to, why one statement is more relevant than another. But when you discuss in deliberations, in formal deliberations, when you can make a point on which you're pretty persuaded that can be corroborated by an authoritative statement by the ICJ or its predecessor, that helps a lot in you finding out of your own conscience that you're making a good argument.
Well, thank you for that, Attila. I think we've now covered a lot of the reasons that the jurisprudence of the ICJ is being relied upon there, and why that might be correct. I just wanted to turn that on its head and just ask, as you say, it may be sometimes in trying to found the novel arguments or trying to push the envelope somewhat. And I wonder whether or not that frequent citation to the ICJ's jurisprudence from an interstate context into a very different context, where the ICJ has a tendency to distinguish whether or not that's actually warranted as much as it is, and maybe whether or not there is a slight degree of unjustified reverence for the ICJ in investment treaty jurisprudence. I don't know if you want to answer that.
Well, I don't, but but I can make some general remarks, and perhaps you can.
I'll do my best.
I mean, if, as Jean-Marc has introduced the point, there may be statements that are more or less authoritative than others, depending on obvious public international or foundational reasoning, namely the affinity of relevance for purposes of that subject matter that the arbitration tribunal is addressing, and the statement made by the court. A point that I want to make is that arbitrators have to exert more caution than counsel when referring to statements out of context. So the context is important. The intertemporal law element is important. And whether a given statement was relevant as evidentiary of the law at the time when the judgment by the World Court was handed down is to be tested against the evolution of subsequent practice, opinion juries, jurisprudence, just like any piece of practice and opinion juries. Sometimes it has occurred that a statement has been taken either out of context or out of time. And I'll stop there.
Paris, any thoughts on that?
So I think I agree with Attila in the sense that it's difficult to generalize when we speak of reverence by ISDS tribunals for the judgments of the PCIJ and ICJ. And it's important to think about how those statements are being referred if we're speaking of being referred to if we're speaking of reverence. And I think Jean-Marc mentioned Professor Pellet's 2013 Le Livre lecture, which had this interesting comment on having sort of surveyed the scene of cases as it stood in 2013. He said that the different approaches of tribunals to the court's jurisprudence range from polite indifference to compelling authority, which I think is an interesting way of characterizing how different ISDS tribunals have approached the reverence, as it were, for ICJ jurisprudence. And really just to build on what Attila said, it's so dependent on the issues each tribunal faces. And if there is authoritative ICJ jurisprudence on a particular issue of direct relevance to a tribunal, then reverence, for want of a better word, is appropriate. But it comes down to the relevance and the application.
Thank you. I wonder sometimes if it isn't counsel just trying to remind the tribunal that it is a regime of public international law and not a self-contained regime there. And in that sense, Attila, you were talking about certain areas, treaty interpretation, state responsibilities, state succession, and so on and so forth. But I wondered if you could maybe touch upon questions of jurisdiction and procedure and other questions such as that, whether or not you also find relevance of the ICJ's jurisprudence and ISDS on those fronts.
Right. In order for me to accommodate your curiosity, I think that The Hague bode well. I had the benefit of attending Eli Lauterpacht's Hague lectures, 1996, on precisely international procedural law. And one of the takeaway from that course that has remained and was later corroborated by the reading of his written course ages after he delivered the course, was the application of Article 38 to not just substantive international law issues, but also procedural law issues. And then who would be bound, benefit from Article 31 through and 1D and the whole structure of applicable law pertaining to procedural issues, if not all international courts and tribunals. That was his saying. And if you look at Hugh Thoroway, Sharptire, Roseanne, later Chester Brown, they also seem to converge in the same direction towards some kind of common law of adjudication, which draws from interstate adjudication. I set out three clusters. I mean, interstate and investor state adjudication is very much inspired as far as procedure, and there I distinguish between hard and fast procedural rules on the conduct of proceedings, but also some of the points that been raised by Jean-Marc, res judicata, obligations to state reasons, the actual curtailment of
You're a Novit Curio?
and the curtailment of the latitude of adjudicative discretion. They're all issues that investment arbitration tribunals can draw from interstate adjudication, whereas certain principles that apply in the same area of jurisdiction part to recharacterize the disputed facts within a human rights litigation context, let alone international criminal law. These are different matters, and indeed, interstate litigation, starting from the two Hague conferences. And I remember that the second Hague conference was convened precisely on debated issues as a matter of substantive law would amount to investment law on state bonds. So it is only normal that investment arbitration relies on procedural principles introduced by world courts in interstate litigation. That is my view. But I see a distinction between adjudicative and procedural principles, whereby in the former case, interstate adjudication may exert authority over arbitration tribunals. Whereas when it comes to certain procedural issues, sometimes statutes of standing courts are not so detailed. And there is where the impact of procedural arbitral practice, including from commercial arbitration, might come to the rescue for standing courts, even, for example, resorting to IBA rules. They don't say that, but they rely on it. And I can assure you from experience, they don't make an official decision out of it. They send the parties a letter, but they rely on the IBA arguments that have been put forward by the parties.
On a less legalistic but more practical level, I remember the beginning of the pandemic, where I think all of us across the Peace Palace, across the world, across investment and commercial arbitration, were trying to grapple with the new reality of how we were going to conduct business during that fraught time. Turning back to you, Paris, I just wondered if you might start to give us a sense of what you think we might see moving forward in terms of more or less influence of the ICJ. We've heard some opinions, maybe we've exhausted those easy topics such as treaty interpretation and state responsibility, and there are fewer opportunities for the ICJ to influence ISDS, or is there still fertile ground left to cover?
Yes, so I think I would break this down between the legal influence of the ICJ moving forward and perhaps the more practical influence that the ICJ judgments may have moving forward on ISDS. So beginning with the legal influence, I expect that we will continue to see parties and ISDS tribunals refer to judgments by the PCIJ and ICJ case law relevant to international investment law. And in particular, I'll be interested to see how both parties and tribunals approach the judgment in certain Iranian assets that we've spoken about already a number of times this morning. And in addition to some of the points that Jean-Marc mentioned about the question of the structural, functional, and the test that was taken by the court at the stage of determining the nature of the bank, the court also made some interesting statements on substantive standards found typically in investment treaties, including fair and equitable treatment, non-impairment, and expropriation. And of particular note are the court's findings regarding the relationship between the state's right to regulate and those standards, which has been such a fraught issue throughout ISDS jurisprudence. So on this issue, the court has now added its voice, and in assessing the various alleged breaches of the Treaty of Amity, considered the, quote, reasonableness of the US measures challenged, articulating various indicia of unreasonableness, including the adverse impact, where the adverse impact of the measure is manifestly excessive in relation to the purpose pursued. So given the relevance of these statements by the court to ISDS on this and other issues, I do think it would be really interesting to see how both parties and tribunals treat this judgment moving forward. As far as I'm aware, it's not yet been publicly cited by any publicly available award. So that's one area of legal influence, one very specific example of legal influence that I'll be interested to follow. As you note, though, how much the court will be called upon to address issues directly relevant to international investment law is another question. As I mentioned at the outset, the court has limited reason, generally speaking, or has had limited reason to address issues directly relevant to the substantive law of international investment law. And the termination of the Treaty of Amity is likely to mean it has even less reason to address substantive investment law related questions. So then turning to consider the practical or de facto influence of the court, which arguably may be more interesting in one sense. Commentators often speak about the cross-pollination between ISDS and ICJ practice, particularly as a result of repeat players in both fora. ICJ judges had been relatively active in investor-state dispute resolution, particularly sitting as arbitrators, referred to as, everyone is, I'm sure, aware, as double hatting. But in 2018, members of the court resolved to restrict that practice and not to accept appointments on ISDS tribunals. So that may impact the practical influence that ICJ practice has, though obviously many arbitrators, whether ICJ judges or not, have deep background in both public international law and international investment law. At the same time as you have this reduction in double hatting, you have an expansion of the pool of counsel before the court, many counsel appearing in both ISDS cases and public international law, state-to-state disputes, as well as commercial arbitration, as you mentioned. So that will necessarily enable one practice to influence the other, at least de facto. And then with respect to the court's procedures, as just foreshadowed by Attila, the court is handling a wider array of cases. Its docket is ever increasing, and it's commonly being called upon to consider both factual and expert evidence, which you see more commonly in ISDS. And to the extent there are gaps in the rules of the court and the court statute on these procedures, we can expect, I'm sure, to see the court borrow increasingly from both ISDS and commercial arbitral practice. One kind of interesting practical point in this respect is that common to ISDS is this sort of ever increasing number of documents that you see, both in terms of the length of pleadings, but also authorities, fact exhibits, obviously witness statements and expert evidence, which can run into the thousands, if not the tens of thousands, depending on how large the case is, number of documents and pages in particular. And the ICJ has itself imposed restrictions on the page numbers of annexes, so now limiting annexes, at least in theory, to 750 pages. So I think we can expect to see both continued legal influence from the court, but it will also be interesting to see more of this practical influence that the two systems have on one another.
Thank you. And Attila, how about you? Any predictions on where this symbiotic relationship will lead us, or even what future cases the ICJ may encounter that will impact ISDS?
Imagination, yes. Taking it from Jean-Marc's introduction, referring to the Institute resolution, the relevance of advisory opinions. Why not guessing, speculating what the impact might be in the future of what the advisory opinion on climate change may be? I think it will certainly have an impact on the calibration of the balance between the international obligations that states have vis-a-vis the international community or on a transboundary level, on the one hand, and the obligations have vis-a-vis the investors. And I suppose my guess is that the court may spell out in some instructive way about the contents of due diligence obligations on part of states, which may impact on the concept of regulatory freedom and sometimes regulatory duties. My curiosity is whether the court will go as far as to make any statements about corporate due diligence, which in that case might help filling a gap that I see as of now without the majority of applicable treaties, when the court is the tribunal is procedurally inclined to declare a counterclaim admissible. When it comes to the cause of action, the arbitral tribunal falls short of finding obligations that have been infringed by the corporate investor, and maybe the court might get into it, might not. We'll see.
Thank you, Paris. Any reflections on? Are you as optimistic? I mean, Jean-Marc alluded to the authority advisory opinions. I think one other thing that adds to that is the court can choose to speak or not to speak.
Exactly.
So when it chooses to speak, it obviously has something to say. Do you think that it will actually speak in a manner that will be relevant to us in the ISDS field?
It's a good question. I'm perhaps not as optimistic that we will get a statement from the court on the obligations, or even an indirect statement from the court that may bear on the obligations of corporate entities. Though I think the impact of any clear statement by the court on states' obligations with respect to climate change, including due diligence obligations, will necessarily have an indirect implication for corporate responsibility and therefore, in theory, for ISDS cases, particularly where there is a foundation for example, a counterclaim. I think beyond that, though, as Attila mentioned, we can expect to see a clear statement by the ICJ, really either way, I think, impact how states renegotiate their treaties moving forward. So many states are already at this stage renegotiating treaties, particularly with this focus on carving out explicit regulatory space as it relates to regulation in implementation of climate obligations. And I'm sure that a statement by the ICJ will contribute to that process and inform how states move forward in those negotiations on this specific question.
Thank you. I wish we could continue this conversation, but unfortunately we've already run out of time there, but I hope that has served to whet your appetite a little bit for the discussions that will follow over this very interesting forum. So with that, I'm left to thank our distinguished speakers here once again. Thanks.